This defendant walked into court expecting a routine hearing, but within moments, Judge Raquel West delivered a warning that changed the entire direction of the case.
Good morning. Are you Joey Mink?
Yes, ma'am.
Let's see. This is Miss Malfino.
Yes, ma'am.
And Mr. Possible, your client waive the formal reading of the motion in each case.
You will, Your Honor.
Mr. Mink, in cause number 23, DCCR 1851, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the offense of evading arrest or detention with the use of a vehicle. And that was a 4-year deferred probation. Is that correct?
No.
And then in cause number 24, DCCR 0294, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation July 1st of 2024 for the offense of aggravated assault with a deadly weapon. And that was a 6-year deferred probation. Is that correct? Each of these cases, motions, I'm sorry, allege that you violated your probations. Count 1 in each case alleges that you failed to successfully complete the safety program. Is that true or not true?
Yes, ma'am.
True or not true? Thank you. Count 2 in each case alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
True.
And then count 3 in each case alleges that you're behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true in each of these cases to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And because they're all actually true.
Yes, ma'am.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rose?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So it looks like the agreement is for, is it safety relapse or the whole safety program? So it's your understanding and you want to go along with going through that whole program again.
Yes, ma'am.
And Judge, I'm sorry, may Ms. Cole just kind of inform the court, she actually had a discussion with Mr. Mink. We were not all on the same page on this initially. Ms. Cole, excuse me, did have the opportunity to speak with him, and I'd like her to relay that to you.
Yeah, of course. Would you raise your right hand, please? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can go ahead.
So I went back there and I spoke with Mr. Mink because he's been acting up in the county jail. When I initially went to the jail to visit him, I told him that you watch the jail reports and to end up on them. So we went back there and talked. He didn't own up to everything, but I told him if he's willing to do the whole safety program from start to finish, starting with 0 tolerance, starting today. And once he gets back in that jail, he better respect those COs. And if not, then he can go to prison at this point. But he's gonna have to behave himself if he wants to continue this program, because if he goes back to safety again, this is it. There's no go back. Once you can only go twice in a lifetime. So this will be his second time going through the program. So 100% zero tolerance.
What was the specific, I guess, of safety? Why did he, what part of safety did he not complete?
He was actually at the end of the whole safety unit placement. He was going to residential aftercare. And right when he got to the end, he just couldn't move. He's hitting, he's fighting, just being youthful. And I told him back there, be 20 years old, you're grown, grow up today.
Yeah,
If he doesn't want to grow up today, I can't do nothing for him.
I can't either. Ditto to everything she said, because that's normally what I tell everybody. And I appreciate that everyone is getting on the same page and understands that the nonsense that's happening out at our jail is just that, it's nonsense. And these correctional officers are just trying to go to work and do their job and go home to their family, and they're having to put up with y'all acting like idiots and treating them with disrespect, and I'm not tolerating it anymore. And so she's exactly right. This is going to be the opportunity of a lifetime for you. It's really the second opportunity of a lifetime. You won't get a third.
Yes, ma'am.
You understand?
Yes,
So if you want to live a life like the rest of us, out, get a job, have a family, do all those things, then it's just a matter of learning to follow the rules. And if there's anger issues, hit a pillow, hit a mattress, don't hit a person. Do you understand?
Yes, ma'am.
I mean, it's kind of funny, but it's really not.
You're right.
You know, you've got to learn to, and that's what safety's for. That's what these programs are for, is to help you be able to do and be better. And so you've got to take advantage of those programs. They're expensive. We're spending money on you for a second time. And so we're doing this because she thinks you're worth it. And that makes me think you're worth it. So now you've got to believe that you're worth it. Make sense? All right, so.
If I could, just to follow up on what the court saying
Yeah.
with what Ms. Cole said, and for Mr. Meek's benefit, as far as the jail write-ups, you're getting safety today, but you still need to behave until you go to safety, because I've had clients in the past waiting to go to safety or ISF, get jail write-ups and come back and end up in prison before they even get there, so. that's for you.
Yeah, you've probably heard some out there that's happened too, because it's
I've
been
seen it.
fairly recent. Yeah.
Yes, ma'am.
So, it's a condition of your probation that you not get write-ups or incident reports in jail while you're waiting or at safety. So if you do, it's a violation, and you're gonna get that motion to revoke, and you're gonna be in here before you ever get an opportunity to go. I'm not gonna waste the money on sending you to safety if you can't behave while you're here. Okay, makes sense?
Yes, ma'am.
Can't remember now where I was, state, did we tender? I don't think so. State tender's number one in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Mink is not competent?
No, Your Honor.
All right, so Mr. Mink, I'm going to find that you entered your pleas of true, in each of your cases to counts 1, 2, and 3 freely and voluntarily. Find those counts true, find sufficient evidence in each of your cases to find you guilty, and send you to prison, but I'm not going to do that. I'm going to give you this opportunity, continue you actually. In cause number 23, DCCR 1851, I'm going to continue you on probation. I'm going to extend that probation for 2 years. That was a 4-year term. I'm going to extend it for 2 years. I want to make sure there's plenty of time, get through safety again, and get out and be on probation for a while, okay?
Yes, ma'am.
To prove yourself. And then in cause number 24, DCCR 0294, continue you on probation and, order that you enter and successfully complete the safety program. I will tell, I mean, it's from what I have, there's been at least a little bit of a improvement, because there hasn't been a write-up at least in a couple of weeks since February 28th. And so hopefully you're on your path there. Everybody out there should be looking at each other and going, don't mess with me. I'm not going to mess with you, because I don't want to go to prison, and I know what the judge is going to do. That's the conversation that everybody should be having out there at the jail at this point. Okay. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you waived any right to appeal. Good luck to you. Take advantage of this. Okay. Thank you for being here, ma'am.
You're welcome.
Dismiss 2 of the 4 cases and
Okay. It's
with time on 2.
got you. Good morning. Are you William Leroy Jones?
Yes, ma'am.
And so, Mr. Jones, in cause number 25, DCCR 1627, you're charged with theft of property with previous convictions from August 3rd of 2025. The indictment alleges that you were previously convicted of theft in 2 cases on June 1st of 2023. And then after that was final, November 16th of 2023. And then after that was final, August 6th of 2024. And then 2 cases, August 15th of 2024. And what that means, sir, is if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in prison, in state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 1628, you're also charged with theft of property with previous convictions. That one's from August 2nd of 2025. It alleges all those same prior offenses. Again, the range of punishment is between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
And cause number 25 DCCR 1629, you're also charged with theft of property with previous convictions from August 9th of 2025. Same prior offenses are alleged, making the punishment range between 6 months and up to 2 years. Do you understand? And then finally, in cause number 25 DCCR 1630, you're charged with theft of property with previous convictions from August 15th of 2025. again, has the same prior convictions listed, making it punishment range between 6 months and up to 2 years. Do you understand?
I understand.
In all of those cases, I have here on the tablet plea bargain rejections that have your signature on them with Mr. Lewis's that shows that the district attorney's office has made an offer if you wanted to enter pleas of guilty. In cause numbers 1627 and 1629 for 20-month terms in the state jail prison with dismissals in 1628 and 1630. Is that your understanding of what the plea agreement is if you wanted to enter a plea of guilty?
Yes, ma'am. Lord.
You have every right to reject that and have all 4 of your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes, ma'am. I do.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, I do.
Okay, I do want to make sure, it looks like we've got 4 different offense dates.
That's correct, Your Honor.
And so, Mr. Jones, the state can, if you are found guilty on more than one of those, ask the court. So if you're found guilty by a jury and they sentence you, and then we have another trial and you're found guilty and another one and another one and another one, which is what we'll do, that I can then, with their request, I can look at the evidence and I can stack any sentences on top of each other to run consecutively instead of the offer, which is concurrently at the same time. Understand that as well.
Yes, ma'am. I do.
And do you want to reject that offer and have your cases set for trial?
Yes, I do.
All right, we'll get them set for trial. Mr. Jones, Mr. Lewis is one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him. I can appoint someone today who can begin preparation for trial a little quicker. Is that okay with you?
May I request to keep Mr. Martin?
You can, sure. All right, so Mr. Lewis will begin preparation for trial and we'll get all of your cases set on the trial docket. All right, thank you.
Thank you.
You can go back with the bailiff.
So,
Pay close attention to the judge's reaction here, because this pause suggests that the consequences facing the defendant could become much more serious.
Good morning. Are you Derek Butler?
yes, ma'am.
And will your client waive the formal reading of the indictment?
He does.
Let's see. Hold on, because we're going on more than that long. All right, Mr. Butler, in cause number 25, DCCR 1653. How many are we going on?
Is
1, 4. Oh, they're all from the same date, so we just enhance one time.
Right. Well, they ran concurrently, Judge, was one point.
Gotcha. So just count 1 and 2 is fine.
Right.
Instead of reading all of them. Okay. So the state has elected to proceed on counts 1 and 2 in your indictment. It alleges that you committed the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from October 16th of 2025. How do you plead to that charge? And are you pleading guilty freely and voluntarily?
free.
And are you pleading guilty because you did what they charged you with? The evading arrest or detention, did you do what they charged you with?
Yes.
Your indictment further alleges in count 2 that you were previously convicted of the 1st-degree felony offense of murder, September 29th of 2004. And is that conviction true? Speak up, please.
Yes, ma'am.
Okay. And are you pleading true, freely, and voluntarily? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like part of your agreement also is that there's potentially something else, Mr. Smith, that refusal of all other charges related to this.
There's a misdemeanor that's already pending down the hall that we will dismiss, and there is potential to file felon in possession of a firearm. We will, part of the deal is we will not file that case.
Okay, that's your understanding as well?
Yes.
State tenders number one.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Butler is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 15 years. Oh, it's a cap. I'm sorry. Let me back up. So, all right, so your agreement is for a cap of 15 years
Yes.
with the refusal of that other charge. I want to make sure you understand you have an absolute right to have a jury come in and determine two things. One, if you're guilty or not, and then the second would be to determine your punishment. If you go this route, then you're waiving that and leaving it up to me with that cap. Is that your understanding? Okay, so then what I'll do is reset the case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and the case. And then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis and he will present it to me on your behalf when we come back.
Yes.
All right, you go back with the bailiff.
Thank you.
Sir, are you Daryl Sneed?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Sneed, in cause number 25 DCCR 1800, you're charged with a second-degree felony offense of burglary of a habitation from April 29th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? Speak up, please.
Yes, ma'am.
Thank you. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sneed is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's?
His criminal history is very limited, Your Honor. I have no objection to a bond pending sentencing.
Okay, and so Mr. Sneed, what I'm going to do based on the nature of your plea is reduce your bond to $1,000. I'm going to make a condition of that bond is that if you cannot have any contact or be around or go to the habitation of Billy Davis. What is that address?
595 Ashley.
2595 Ashley. So you cannot go anywhere near that location. Okay, that's part of your bond if you make it. If you make your bond, then it's very one of the first things you do is go to probation so they can start that report. If you don't do that, then you run the risk of me not accepting the plea agreement and things could be worse. If you're arrested for anything between the time you make bond and come back for sentencing, obviously I don't have to accept the agreement and things could be worse. And then finally, if you violate that condition of your bond and have any contact with or are around the address that I just stated, then you obviously run the risk of me not accepting the agreement. Do you understand? All right, we'll see. Yes,
I'm
ma'am.
sorry. Mr. Sneed wanted me to ask if the court would consider a personal recognizance moment.
At this point, because of the nature of the offense, I want to make sure that there is some bondsman. It's as low as I can make it at 1,000, so that if he makes that bond, at least there's someone making sure those conditions are being followed.
Yes.
Based on the nature of the offense. Okay. All right, you can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Good morning. Are you Jerry Terrio? Can you hear me? Okay, I need you to speak up so the court reporter can hear you.
Yes.
Thank you. And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Terrio, in cause number 24, DCCR 2442, you're charged with a state jail felony offense of theft of material from October 25th of 2024. How do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1.
Yep.
Before you signed these, did you go over them with Mr. Parker? Speak up.
All right, pick up.
You speak up.
Yes,
Do you fully understand those documents you signed?
yes,
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
yes,
Do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Terrio is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft of material.
Yes.
Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes.
I'm going to hand you the trial court certification that shows this was an agreement and I followed it, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. You need to read that document. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. Good luck to you, sir. You can go back with the bailiff.
I'm gonna go talk.
Thank you. Feel like I did. Good morning, sir. You Joshua Smith? And this is 25 DCCR 1739. Mr. Smith is charged with fraudulent use or possession of identifying information, 50 or more. And what is the announcement?
Judge, this is the one that we had some issues or problems with the criminal history information that we had in regards to this. I think we got it resolved now to where we try to move forward with this situation. The individual setting will be enough. I've talked to Mr. Smith now. Well, he's want to put an offer out that I just need to go over with my client.
Sure. So we'll just do a normal reset, Mr. Smith. That'll give Mr. Lewis some time to get out there and visit with you now that he has all that information and everything's worked out, and see if we can get it at that next court date. All right, you can go back with the bailiff. Hey, sir, you Travis Cormier? And this is cause numbers 25 DCCR 1448 and 1449. Mr. Cormier is charged in each of those cases with assault on a security officer. Mr. Cormier was evaluated for competency to stand trial by Dr. Hamza. I've received that report, which is dated February 9th of 2026. The finding in his report is that Mr. Cormier is currently not competent to stand trial, and that inpatient treatment for competency restoration would be necessary. Is there any other evidence with regard to competency?
Not from the defense judge.
Not from.
In the end, Judge Raquel West made it clear that the defendant had been given an opportunity to avoid a worse outcome, but the warning from the court could not have been any more serious.
All right, then at this time, in each of the cases, I am going to find Mr. Cormier not competent to stand trial based on that report. I am going to order that Mr. Cormier go to the appropriate facility for competency restoration for a period of not to exceed 120 days from the date that he gets to that facility, and then we will await their report with regard to competency restoration. I'm not sure which one it'll be, but you'll go to a hospital so that you can get whatever you need, so that you can. I'm not sure. It might be not Fannin, probably. It's going to be somewhere else. And
Today?
it'll be soon. All right, so you're gonna have to wait in the jail until they have a bed for you. It might be a little while.
Okay.
Then they'll send you, so if you're in jail and there's medication that they're trying to get,
Already on my meds.
make sure you take all your meds, because if you get better and feel like you understand things, we might take care of this.
For the rest?
No, no, we're not taking care of anything right now other than getting you where you understand everything, okay?
Okay.
All right, you can go back with the bailiff.
Alright. Hey.
Good morning, sir. Are you Clifton Alton Keller?
Yes, ma'am.
This is 25 DCCR 1462. And Mr. Keller, you're charged in that case with the second-degree felony offense of arson from July 15th of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, November 17th of 2008. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be enhanced to that of a first-degree felony if that prior conviction's true, which means your minimum punishment would be 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that and go to trial and have a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Absolutely.
And you want to reject that offer and have your case set for trial.
Yes, ma'am.
And is there any reason to believe that that offer would change?
No, Your Honor.
So I just want to make sure you understand, Mr. Keller, that once you're on the trial docket, your case will be expected to either go to trial, or if you change your mind and you want to enter a plea of guilty, it would be open to the court or some different plea agreement. Do you understand?
Yes, ma'am.
All right, then we'll get your case set for trial. Mr. Keller, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles several cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
So you want to get rid of Mr. Lewis?
It's up to you. You
No.
can keep Mr. Lewis or you can get another attorney.
No, ma'am.
All right, so Mr. Lewis will begin preparation for trial. All right, you can go back with the bailiff.